Hi, my name's Emma. I'm the program manager at Reef Asylum Support. Um, since President Biden was inaugurated a few weeks ago, we've heard a lot in the news about immigration reform. The proposed bill that he sent to Congress, as well as several executive orders that he signed on his first day in office, and several more that are expected this week. And we know that for many of you who are going to be impacted by some of those proposals, the process of how a proposal is made and then how it becomes a law or is implemented as a policy can be confusing to follow on the news. And so we've decided to put together a series of resources, these short videos, that will explain the different mechanisms by which a proposal is made, a bill becomes a law in Congress, or a policy is implemented by one of the executive branch agencies. This video specifically is going to focus on the executive branch and how they implement immigration policy. What do I mean when I say the executive branch? I'm talking specifically about the president, the office of the president, that's all the staff that support the president, and then the executive agencies, which the president oversees. These include, for example, the Department of Homeland Security, U.S. Customs and Immigration Services, USIS. So that's going to be the focus of this video. We have a separate video talking about President Biden's proposal to Congress and how Congress might go about addressing some of the immigration reform that's being talked about in the news. That video, the link to it is in the description for this video. So click on that if you're interested. Before we get into the meat of it, I'm going to give an overview of what we're going to talk about. I'm going to use two Trump administration asylum rules, both related to work permits for asylum seekers, to illustrate the process by which an executive branch agency implements a policy. This happens through what is called the rulemaking process. The rulemaking process is very procedural. It's set out in the Administrative Procedures Act. And there are lots of rules that govern how it happens. Both of the Trump administration work permit rules went through the rulemaking process. And then if President Biden were to implement new immigration policy during his term, DHS and USIS would also have to go through the rulemaking process for the most part. The two rules I'm going to focus on are the reversal of the requirement for USIS to process work permit applications within 30 days. That rule went into effect on August 21st, 2020. It now means that USIS can take as long as they want to process a work permit application submitted by an asylum seeker. The second rule is the 365-day waiting period to apply for a work permit after you submit your asylum application. This replaced the previous rule, which only required asylum seekers to wait 150 days to apply for their work permit after they submitted their asylum application. This rule went into effect just a few days later on August 25th, 2020. Another rule that's, a lot of us have been focused on this year was the Trump administration's most comprehensive rule around asylum that was set to go into effect on January 11th, 2021. However, on January 8th, it was blocked by a judge. So it never went into effect. It won't go into effect. That rule, it was huge, but generally it aimed at just increasing the discretion of asylum officers and immigration court judges to deny asylum claims for a variety of reasons. But again, this was blocked by a judge. I've put it here in orange, I'm not going to talk about it because it was blocked, but I know some of you may be thinking about it and wondering why I'm not going to bring it up. So just wanted to raise that here. A few disclaimers before I start explaining the rulemaking process. This is a hugely complicated process. There are legal professionals who spend their entire careers focused on understanding, interpreting, implementing this process. I am not one of those people. This is the most basic possible kind of overview of the steps of the process so that, for us, we're not steeped in this topic. We're not focusing our careers on this topic, but still when we read the news, we can follow along with what's happening. The second disclaimer is that not every policy that's implemented goes through the rulemaking process. There are certain exceptions. Even within the rulemaking process, there are different caveats, different ways certain things are done, depending on the circumstances. And I'm not going to get into that level of detail here, but you should be aware of it. Just because, there might be an instance where a policy is implemented and it doesn't go through this process. But by and large, this is the process we're interested in, or that's going to most impact kind of asylum seekers when it comes to implementing new rules that are going to regulate asylum. The third disclaimer is that we don't totally know what the Biden administration is going to do yet. The first week after the inauguration, there was not a lot of news coverage, like bill delivered to Congress, executive order signed, that, it's easy to read that news and think, okay, this is all done and finalized. But in fact, it's just the very beginning of the process. And even before we start to get into the stage of implementing a policy, there's still negotiation, and there's compromise. For example, in the last 2 weeks, we've seen, the Biden administration shift its stance a little bit from having delivered this very comprehensive proposal on immigration to Congress and saying, this is the Citizenship Act of 2021. Now they're saying, if Congress wants to separate this bill into several pieces and take on one topic at a time, we're open to that, So that's just one indication of how once a proposal is made, even if it's presented as being very concrete, there's still a lot of ways things can change even before we get to policy implementation. And the rulemaking process is policy implementation. We at REEF, we're keeping our eyes on the news. We're going to keep you updated on new proposals and, where they're at in the process of being implemented, negotiated and implemented. You can find those updates through our asylum alerts on our website. I've put the URL here on the slide for you to check out. And our hope is that as we update that resource, that webpage, you can kind of come back to this video to understand where are we in the process with policies that are going through the rulemaking process. We're at this stage, this is what's going to come next. And to give you a kind of better sense of, how are these rules going to impact me? When are they going to impact me? And what can I expect before they go into effect? So with that, let's get started. As I mentioned, I'm going to use two of the Trump administration's work permit rules to kind of illustrate how this process works. The first is the reversal of the 30-day processing requirement. This rule allows users to take more than 30 days to process a work permit application from an asylum seeker. Previously, they had been obligated to process a timely submitted application, properly submitted application within 30 days. However, we know in practice that it often took longer. Where does this rule stand now? It's in effect. There is an ongoing court case to block the rule from going into effect. Because of the court case, the rule does not currently apply to members of CASA or ASAP. Many of you who are applying for work permits right now will know that we're encouraging people to become members of this organization in order to receive this protection. So what could happen moving forward? There are really three paths ahead of us. First, the court could decide to block the rule, which would mean that in effect, we would go back to the 30-day processing requirement that would apply to all asylum seekers. Second, the Biden administration could overturn the rule with a new rule that returned us to the 30-day processing requirement. And that rule would have to go through the rulemaking process. Third, and least likely, Congress could pass a law that would make the rule unlawful. So Congress could pass a law that says USCIS is required to process all applications within 30 days. And then because that's the law, the executive branch agencies would have to implement it. And that would require us to return to the 30-day processing requirement. I put this in italics though, because it's the least likely. I wouldn't even consider it as one of our paths, but put it there so that you understand the mechanisms, the more general mechanisms of how this works within the US government. The second rule is the 365-day work permit rule. This rule requires asylum applicants to wait 365 days after their asylum application receipt date to apply for a work permit. Previously, the rule had been that asylum seekers have to wait 150 days, so about half the time, to apply for their work permit. So this extended the waiting period. Where is the rule right now? It's in effect, but because of the same ongoing court case that I mentioned in the previous slide, the rule does not apply to CASA or ASAP members. And so CASA and ASAP members right now are allowed to apply for their work permit 150 days after their asylum application receipt date. Where could we go from here? It's the same three paths. The court could block the rule, in which case we would return to the 150-day waiting period for all asylum seekers. The Biden administration could overturn the rule with a new rule, or Congress could pass a law that would make this rule unlawful. And so the agencies would have to change their approach. In both of these instances, we're kind of waiting to hear what this court's going to do with this case. But apart from that, the other way we could reverse these rules is through a new rule implemented by USIS under the Biden administration, and that would have to go through the rulemaking process. So that's what we're gonna talk about here. The federal rulemaking process. This is governed, as I said, by the Administrative Procedures Act. It's a very specific process. You can go read the act. You can Google it and see the text of the whole act if you're interested. I'm going to go through the stages of this process. First, an agency is going to decide to make a rule, and there are a couple ways this happens. First, agencies exist, every day and they've been given authority by Congress and by the president to do what they have to do to get their jobs done, right? And so in the course of their day-to-day work with the authority they already have, they could say, we need to implement a new rule to do our jobs better, or to fix a problem, or to be more efficient. That's one way an agency could decide they'd have to make a new rule. Second, the president could ask an agency to make a new rule or to implement a policy, right? This is something often done, for example, through executive order. And we've heard a lot about executive orders recently. That's the president saying, I'm going to enact this policy. And then agencies, see that and say, okay, in order for us to implement what the president wants, we need a new rule. And so this initiates the rulemaking process. Third, Congress could pass a law that would ask an agency to do something or change the authority of the agency in a way that forces them to make a new rule to implement that law. So those are the three ways the rulemaking process can be triggered. Next, the agency has to prepare the rule. They write it out. They think about the mechanics of it. Does what we've written here really implement the law or the executive order that we're responding to? That happens within the agency. In the public, we're not really seeing that part of the process unless, we are involved as kind of experts or we're advisors in some way, but most of the public's never going to be involved or see this part of the process. Then the proposed rule undergoes review and analysis. And this gets back to what I said about the Administrative Procedures Act, is that it's a very specific process that includes a lot of checks and balances, right? So this whole stage is about, or rather, let me back up. There's a whole part of the federal government, offices in the federal government, whose only job is to do this. An agency makes a rule and then hands it off to these offices, and these offices have to review the rule. They make sure everything looks right. It follows all of the standards of how a rule is written. They make sure the legal argument for why the rule needs to, the legal argument for why this proposal is being made, they make sure that looks good. And then in certain cases where a regulation is anticipated to have a significant economic impact, the government is also required to do a cost benefit analysis and essentially justify, despite the cost of this rule, it's still worth it because of X benefit. This is another stage of the process that really, it happens, behind closed doors in and around Washington. And we don't really see this part of the process, right, as the public. But I include it here as well for us to understand, how long this process can take. This is a period of time, right? I'm going to bounce around a little bit, but to say a little bit about the timeline. Both the August 21st 30-day processing requirement rule and the August 25th 365-day waiting period rule, both of those rules were proposed in November of 2019, right? That's when the rulemaking process began for them. So we're looking at an entire year nearly, about 12 months of time between when the rulemaking process started and when the final rule went into effect. This is a lengthy process. Even for the January 11th rule that was blocked by the judge, so it's not going to go into effect, but it was set to go into effect on January 11th. That rule was proposed back in late spring of 2020. So we're talking there even a 6-7 month timeline. So that's, these are the steps that are happening behind the scene that can make this process take time. So once the agency has made the rule, it's been reviewed, all the necessary checks have been done, they're ready to make an announcement to the public. And they do this through a notice of proposed rulemaking. This is the technical term for it. This notice is published in the Federal Register. What is the Federal Register? We often talk to people who aren't familiar with kind of the mechanics of US government yet, who are always kind of surprised by this. But every US regulation is available for search. I mean, since 1994, I believe it is. The ones that are available electronically are available for search through this website, the Federal Register. It's the electronic depository for all things related to the federal government. So you, as a member of the public, are able to search any regulation and kind of see the history of that regulation and other things. Later in this presentation, I'm going to go to the Federal Register website to show you one of the rules that we're referencing. But for now, just so you can kind of see this image in the corner here of what that website looks like, and it's a literal website we can go to search federal government regulations. So the notice of proposed rulemaking is published in the Federal Register, and that's what lets the public know this agency is proposing a new rule. Then begins the public comment period. This is a period that ranges from 30 to 180 days, depending on the complexity of the rule. And it's an opportunity for the public to submit comments in support of or against the rule. Comments can be submitted electronically through the Federal Register's website. And you'll often also see a link from the agency as well. So if USIS has issued a notice of proposed rulemaking and the public comment period has started, you could find it on the Federal Register's website, but often when you open USIS's website and go to the topic that the rule is related to, or the proposed rule is related to, you'll see a link to it there as well, right? They have an obligation to make this information available to the public. So this is a question we get all the time. Can I submit a public comment? Should I submit a public comment? The short answer is yes. Anyone can submit a public comment. Any member of the public. You'll be required to give your first and last name, but beyond that, you're not even required to give contact information, though it can be helpful. But then, should I submit a public comment? And the answer to this question gets a little more complicated because not all comments are equally useful, right? That's how I'll begin. The agency receiving the comments is legally required to read every comment and consider it, but they're not required to respond to every comment. They're only required to kind of respond or look further into comments that are based on legal arguments or data-based arguments. And let me explain what that means. A legal argument, in the case, for example, of these work permit rules, a really common argument that was made at the time is that DHS did not have the authority, the statutory authority, which means the authority given to it by the law, to implement these rules, right? And that was it. It was a highly legal argument. Those comments, they would point to places in the US code and US law to make the case, to make the argument, right? And you can see in the final version of the rule that a substantial amount of the document is devoted to responding to that argument that was made in public comments, right? That would be a legal argument. A data-based argument would be one, for example, I'm a researcher, whether I work for a nonprofit organization or at a university, and I have lots of data sets about asylum seekers, financial well-being, right? What they're making, where they fit into the economy. And I could make the argument, I could say, based on X source, this data I have from this place, I project that if this rule goes into effect, a certain percentage of asylum seekers are going to drop below the federal poverty guidelines, right? That's making a very concrete economic argument using data, right? And in both of these cases, that would be a data-based argument. In both of these cases, the agency that's implementing this new rule or has proposed this new rule will have to look further into those and respond to those pieces of feedback very concretely in their final rule. Often when there's a public comment period, especially kind of around a rule that's seen as particularly harmful to a certain population, this was the case with the Trump administration's last asylum rule that was very comprehensive, you'll see a lot of organizations organizing the public to submit public comments, right? In some ways, this is useful. There's a strategy there, right? Like if everyone submits public comments and the agency has to take the time to read them, that slows the process down, right? And in the final version of the rule, they have to acknowledge we received a lot of comments from people that are against this rule. But they don't necessarily have to look deeper into it, nor necessarily is it going to put them in a position where they might have to shift what they're going to do on the rule. So for example, if I say, I'm a member of the public and I say, I don't believe in this rule because I believe it is going to harm asylum seekers, period, sign my name. They'll say, check, okay, we received another comment a comment against the rule, but what are they going to do with that? I haven't given them a lot to do with that. So while it can be strategic to flood an agency with comments that are against a rule, it generally the rules that are going to have the most influence on the final rule are going to be ones that make these legal arguments and these data-based arguments. And there are tons of resources on the internet that kind of help you think about how to construct a comment around a legal or a data-based argument if you want to do that. And then there are a lot of advocacy organizations that are doing this too. So, if a rule comes out and you feel strongly about the content of the rule and want to submit a public comment, there are definitely resources out there to make sure that you submit a comment that has the type of influence that you want it to have. So that's what I'll say on public comments. After the agency receives all of the comments, they'll read them, they'll do more research, they'll respond to them, and then they either publish the rule as it is, or if based on the arguments made in the comments, they have to make changes, they'll do that, and they'll publish a modified final rule. The final rule is then published in the Federal Register, including the date that it's going to go into effect. And I'm going to pivot now to go through the Federal Register with you. So this is the Federal Register's website. You can see here, federalregister.gov brings me right to this page. And there are two places where I can search, right here and right here. So I'm gonna search the 30-day processing rule, which you can see I've searched this in the past. Down here, you'll see you can limit your search to the type of document you want to find. So at the beginning, you could find a notice of proposed rulemaking, a proposed rule, or a rule that's final. You don't have to click on any of these. I'm not going to. I'm just going to do the general search. And because I'm using a very, very precise search term that I already practiced, it's the first thing that's going to pop up for me, right? So this is the August 21st rule that reversed the 30-day processing requirement for USIS. And when I click on that entry, it's going to bring me to the page that describes it. And I see it's a final rule. Here's the title. I see the agency, the Department of Homeland Security, and within that USIS. It's a final rule. We have the summary of what the rule includes and the date it's set to go into effect. And then if we keep scrolling, we have the table of contents for this whole, the rule is this huge document with all these supplements attached to it. And we'll see the first part is an executive summary. The second part is background and discussion. But I want to turn your attention to the third part, response to public comments on the proposed rule. And from right here, I'm going to begin scrolling, and I'm going to scroll and scroll and scroll, and you'll see all of this all the way down to the beginning of part 4. All of this is the agency responding to the comments they received. And so the public comment period can be very effective to force an agency to reconsider the impact of a proposed rule. The other thing I want to draw your attention to is the publication date. This rule was published to the Federal Register on June 22nd, 2020, but the effective date is August 21st of 2020. When a rule is published to the Federal Register, there needs to be a minimum of 30 days between it being published and when the rule goes into effect, but it can be longer as well. So in this case, for example, we see that there were about 60 days, 2 months between when the rule was published and when it went into effect, right? And I'll say it once more so we keep the timeline in mind. This rule went into effect on August 21st, 2020. It was proposed. The notice of proposed rulemaking was issued on November 7th, I believe, 7th or 8th of 2019, right? That's nearly a year between when the notice of proposed rulemaking was issued and then the final rule went into effect. So I encourage everyone to come here. This website it seems, it's huge. It's kind of daunting. It's intimidating, but it's full of information. It's information that's available to you as a member of the public. So back to our presentation. The question that's on all of our minds is, can a rule be overturned? As we think about, what is going to be the continuing impact of the Trump administration's attempts to really dismantle asylum, can we change some of these work permit rules? And the answer is yes. There are 2 paths, with 3 paths. Well, okay, let me back up actually. Can a final rule be overturned? And, after it's been published to the Federal Register. Immediately after it's been published to the Federal Register, Congress can send a resolution of disapproval to the president that says, we don't like this rule. We don't think this rule should go into effect. And the president has 2 options. The president can either sign the resolution of disapproval. That would be the president says, Congress, I see you don't like this rule. I also don't really like the final version. So we're going to scrap it and we're not going to implement it. Or the president can veto the resolution, which means that Congress says to the president, we don't like this rule. The president, in effect says, I hear you, but I still like the rule and I want it to go into effect. And so I'm going to veto your disapproval and the rule is going to go into effect. Congress has one more course of action if the president does this, and it's to override the president's veto. This is one of the ultimate checks that Congress has on the power of the president. So if enough members of Congress, it needs to be 2/3 of a kind of significant majority of Congress thinks that this is a bad rule, they can vote to override the president's veto of the rule. It's worth noting, though, that congressional override of a presidential veto is something, and I know it's like, referencing all these terms that stack up on each other, but a congressional override of a presidential veto is something that has happened very rarely in the history of US government. Only a couple handfuls of times. So I include this here not because it's likely to happen, but just so that you understand the mechanics of what the final courses of action could be. So Congress can either send a resolution of disapproval, or a rule can be challenged in court. And the Administrative Procedures Act deliberately creates a lot of opportunities for judicial review of new rules. And when we say, and of rules generally made through the rulemaking process, when we say judicial review, I'm referring to the authority of the court system in this country to kind of look into rules and regulations and determine whether they are either legal, whether an agency has the authority to do what they're trying to do, or whether a rule is kind of harmful without justification, unjustifiably harmful to a population or to the public. A court can block a rule from going into effect, or if the rule has already gone into effect, a court could decide to undo the rule. And that's really what, in the case of this court case on the 2 work permit rules, that's what we're all kind of hoping for, is that the judge will determine that either, DHS didn't have the authority to do what they were doing, or that the rule is unjustifiably harmful, and will block the rule and it will be undone. So we've touched on a lot here. I'm going to summarize the takeaways, with, specifically in reference to these 2 work permit rules. Both of the Trump administration work permit rules have been temporarily and partially blocked by the judge who's hearing the Casa de Maryland versus Wolf court case. When I say temporarily and partially blocked, I'm referring to an injunction. Injunction is the term given to an action that a judge can take. An injunction is when a judge decides, just looking at the basic evidence here, it seems like there might be a case. It seems like there might be something wrong with this rule, and so for now, I am going to make it so the rule does not apply to the people who brought the case to me, and that would be CASA and ASAP on behalf of their members. And that's why the rule doesn't apply to CASA and ASAP members right now. But when the judge makes a final decision on the case, whatever that final decision is will apply to all asylum seekers, right? The injunction is just temporary, and it's while the case is being heard. So this raises a question like, what's the timeline here? And the answer is, at REEF, at least, we don't really know. We haven't seen anything on the topic. So it's hard to say. We'll keep you updated as we hear more. The other question is, what could the outcome be? And this is also really hard to say. The fact that an injunction, the judge chose to provide an injunction here, indicates that there may be some merit to the case, that the case may have some legs to stand on. Additionally, it's being heard by District Judge Paula Zinnis of Maryland, who was an Obama nomination, a nomination by President Obama. So these things can provide some indicators, but anything beyond that would be conjecture at this point. We're really just waiting to see. The other thing that could happen is that USIS under the Biden administration could make a new rule to reverse the Trump administration work permit rules. And this would happen through the rulemaking process, right? Again, it's really hard to say whether the Biden administration is going to take work permits on. Of what we've read so far, we haven't seen that topic come up specifically. So this is also a bit of kind of waiting to see. So in the meantime, what can you do? We propose 2 courses of action. Let the organizations that you're connected to know that this is an issue for you. You know, asylum in the US is made up of so many different elements. But for asylum seekers in New York, who are largely going through the affirmative asylum process, this work permit rule is one of the most harmful rules on the book right now, right? That exists right now. And if you let the organizations that you're connected to know, then they can let their advocacy offices know. And their advocacy offices are going to be more well connected to local, state, and federal government than you as an individual are. So let them speak on your behalf. But you got to let them know that it's an issue for you. The second thing you can do, and I encourage you to, is to look up your local elected officials at the kind of federal level. So who are your representatives in Congress? Who are your senators? And write to them and let them know that this is an issue for you as well. Because as we know, immigration is an issue that's going to be tackled both through, or immigration reform is going to be tackled both through the executive branch as well as through Congress. And then, you know, whether a proposal begins in Congress doesn't mean it might end there. You know, the executive branch could take it on, or vice versa. And so if you let your elected officials know, your representatives and your senators know that this is an issue for you, then there's someone who's going to be involved in that negotiation, who's heard from a constituent. Work permits, the work permit rules are hurting me, right? And it might inform their next steps. So those are 2 things you can do. As always, you can also get in touch with us if you want more ideas. And then finally, I will leave you with this. If you have any questions, please join our Wednesday information hours. It's a time when the REEF team we're available on Zoom. You can drop in, you don't need to make an appointment, and ask us any questions you have. If you want to talk about these issues further, the info hour is from 12 to 1 p.m. It's on Zoom. The link is on our homepage, the homepage of our website, reefnyc.org. And if you click the link on the homepage of our website, it'll take you right to the Zoom call and you can meet with us and ask questions. Thank you for watching. We'll continue to produce more of these resources. If there's anything specific you want to see from us, please let us know. But for now, bye.